Hi, good afternoon and greetings. My name is Sudev Sridharan and I'm the CEO of EPLI Asia Singapore. Welcome to our seventh webinar in our Arts and Science series. And the topic for today is on managing domestic inquiries at the workplace. For those of you who are viewing this webinar via YouTube, please click the subscribe button. You will be able to view all the videos from our previous webinars here. And do share the link and the videos of our EPLI Asia YouTube channel and the videos to your colleagues and friends. Also, look up EPLI Asia on LinkedIn and Facebook and join us there for updates on EPLI's HR risk management solution and also our future webinars. Employment Practices Liability Insurance, or EPLI, and that's what we are all about, is a HR risk management solution that was designed by EPLI Asia Singapore Berhad. It is a standalone employment insurance for Malaysian employers that protects you against wrongful dismissal claims that arises from employment disputes. Here at EPLI Asia, with our EPLI product, we offer a 3-in-1 solution whereby we educate, advise, and protect businesses in employment-related disputes. For details on how your company can actually purchase the EPLI policy by EPLI Asia Singapore Berhad, do visit us at our website at www.epliasia.com and leave us a note there. Or you can actually email us your contact details at epliasia.com, all right, at epliasia.com, and we will contact you as soon as possible. And also, join our product briefing on Zoom, which is conducted live every Thursday at 2 p.m. So, for today's Arts and Science series, once again, we have our experts, Supra and Daman. But there's going to be a little twist for today's session. Instead of the usual review, presentation, and Q&A that we normally do, we intend to change that format around a bit and replace it with a presentation. Replace the presentation with a case study, and both Supra and Daman will deliberate on the processes, do's and don'ts of a DI. And after that, we will actually attempt to answer as many questions as possible. Honestly, based on our experiences on the various DIs that we have actually advised upon, and we have actually compiled quite a number of questions. But we would like to hear from you too. So drop us any questions that you may have in the comment section, and we will get our gurus to actually answer as much as we can. Yeah. So have you got your coffee ready? Let's kick off the presentation and discussion by me introducing our HR guru, Mr. Supramaniam Ramasamy. But again, before I hand over the session to Supra, here's a question for Daman today. As we always say in EPLI, even good employers get sued. Even after doing the right thing, employers still lose cases. And the example to this is a case that I had experienced in the previous organization that I actually served. We did everything right. The employee was guilty and even admitted to his wrongdoing, which was a serious misconduct. Nevertheless, what happened was when the case was actually mentioned in court, his lawyer actually started questioning the DI panel on their experience and their knowledge, and instead of focusing on the case per se. So my question is it important that the DI panel is knowledgeable and experienced in HR matters and the technicalities of conducting a DI? So with this, I hand over to you, Supra.
Hi, good afternoon. Good afternoon. Thank you, Sukhdev. Welcome again to EPLI's August Art and Science series. Our topic, as mentioned earlier, the art and science of conducting domestic inquiry at workplace. We have got 4 goals that we would like to establish today. One is to understand what is domestic inquiry in detail and what is the purpose of actually conducting a domestic inquiry. How do we conduct a domestic inquiry? Okay. And lastly would be, what are the best practices of domestic inquiry that we could adopt and adapt to, given, we've got businesses of many sizes and many, in terms of head count, industries and all that. So we might need to be able to adapt to the situation instead of, just having to follow a certain stringent guideline. And please welcome my partner in crime, Mr. Daman Sivalingam, the managing partner of Daman Sivalingam and Partners. When I meant crime, it's more like when I have done the termination process for the clients, right? He will come in to pick up the pieces and start sorting things out in court, okay? Not like crime, okay? Obviously, he
Good
wins more.
afternoon.
Good afternoon, Daman. Thank you.
Good afternoon, Supra. Good afternoon, Sudhir.
Okay, let me start by giving you a textbook definition of domestic inquiry, okay? Domestic inquiry, as we all know, is an internal investigation process that is initiated when an employer needs to determine whether an employee has committed the act of misconduct. Okay? So, under Section 14 of the Employment Act, employers have a statutory obligation to conduct a due inquiry to ascertain whether an employee is guilty of misconduct before they can dismiss or impose a major punishment or penalty on them. Since the burden of proving the dismissal has to be fair on the employee, it is important for employers to get their facts straight and not make hasty decisions based on hearsay evidence or mere suspicion, as emotional decision will be scrutinized in the industrial court. The next hour or so will address the nitty-gritty of domestic inquiry, how to do it, why do it, and also the challenges of conducting DI in a smaller business environment. Shall we start, Daman?
Let's go.
Okay. Yep, good. As I stated the textbook definition, maybe you could share with us, the definition of domestic inquiry from the context of employment.
Okay. Um, I suppose you're going straight for the meat. I mean, the session is about a domestic inquiry. I would like to sort of generally say that I'm not a big fan of labels. I'm also very cautious, and I think I know why you're sort of smirking, because it's these definitions um, have to be used in a real situation with humans coming into the picture. So the definition is nice from a textbook, but when you bring the human and the actors in there, thinking that you're going to get that definition, okay. So I just want to just stop there and tell you that we are humans, we are not robots. So the definition may not translate into action when you bring in the human element. So that's why I'm not a fan of it, but fair question. I would say I'd like to go with a simple answer from an employment law perspective. The domestic inquiry is the accepted forum to determine if an employee has committed a misconduct or not. I would define it that way. Again, define, I don't think there's a precise definition, but from an employment law perspective, we are like, did he have that forum where the assessment of whether he or she committed the misconduct happened? It's about that forum. That's the domestic inquiry.
No, the reason, right, is I think we have done a lot of definition and webinars and trainings and gone through a lot. I think it's very important for us when we are doing our webinars, right? It's basically we really want to get to the essence of it, and be real about things. You know what? Sometimes we have got like 7 different procedures of doing something, and it's impossible to do it in a work environment. As though that we are just going to be in work and just do that one domestic inquiry, which will take 2 weeks downtime, right? So coming back to this, right? Is the word domestic inquiry the same as due inquiry used in the Employment Act? Because the EA says due inquiry. Does it actually means domestic inquiry?
Okay, right. So you just hit a sensitive nerve, lah. Okay, in my opinion, because you're right. If you were to go through any of our legislation, the statutes, you would not find the term domestic inquiry used anywhere. The closest is Section 14, which you highlighted, and even then, Section 14 uses the word, like you rightly pointed out, due inquiry. So let's straight away, and I'm sorry to be trying to be cheeky or whatever, but let's straight away eliminate something which is, I think it's important to eliminate, which is, I don't think anybody can say it was a typo mistake from domestic is what I wanted to type in the Employment Act. Accidentally, I slipped and I typed due, right? Okay, so I think we have to understand that it was intended. And let us respect the fact that the draftsman who drafted the Employment Act, I think, would know of the term domestic inquiry. He's an expert drafting the Employment Act. Cannot be somebody who doesn't know the law, right? But yet, purposefully, the words domestic inquiry was not used. So we need to respect that there is a differentiation. My view. However, the general body of law, if you look at all the cases that go to the industrial court where it's misconduct, the generally accepted principle, especially when you're talking about a dismissal, if the punishment is going to be a dismissal, and let me just quickly pause to say, misconduct doesn't mean it's a dismissal, right? If it's lateness by 10 minutes, it's a misconduct, but you wouldn't dismiss. So, but if you come down to a misconduct which leads to a dismissal, the general cases over the years, many years, the industrial court has endorsed domestic inquiry as the right tool to manage misconduct, especially if it leads to a dismissal. So I think, to answer your question, it's not the same. I think we should respect that. But the practice has made it almost like a law. Almost like, because if you go into the industrial court and let's say you try to bring in a new process, I don't know what that process is even, a new process. The industrial court chairman is going to think, hello, we've been running industrial court since 1967. We've been doing domestic inquiries. Now you are bringing artificial intelligence law or whatever that process is. I think you're going to be having resistance from the industrial court. So I hope I answered your question.
Okay, you haven't finished with all the questions. Okay, when we talk about, as you mentioned about domestic inquiry, so where did domestic inquiry actually come from? Is it from certain practices in industrial court, or is it, someone crafted a new amendment to the act or a new ordinance?
Okay, so my answer to that is the domestic inquiry, the way we have in our mind, the way the industrial courts, the body of the law has developed, stems from the need to be fair, right? And which is why I think you were probably going to probe a little bit further. But I guess where it came from is, okay, we need to be fair. That's the starting point. And over the years, the practice has been slowly shaped, molded, until we came to a landing. Hey, this platform or this forum of a domestic inquiry seems to be fair. And then that became the accepted norm. So there isn't a law which states you must have a domestic inquiry. And a domestic inquiry by definition must mean A, B, C, D, E, F. It starts from the need to be fair, but unconsciously we have codified what fairness is to a domestic inquiry, if that makes sense.
So technically we have complicated the process for ourselves.
I think in some cases we have. I think the bar is unrealistic in many cases.
Okay. So can we assume here that domestic inquiry is not really required under the law for employees who are above the Employment Act? Okay, because it states in the Employment Act, right, due inquiry, So those who are governed under Employment Act, okay, it's a must, okay, whether do due inquiry or domestic inquiry, right? So those employees who are outside the Employment Act scope, right, meaning I don't necessarily need to do a domestic inquiry.
Okay. So to me, that distinction between those within the Employment Act and outside the Employment Act stops being useful the moment we go under the Industrial Relations Act and end up in the industrial court. Because the industrial court does not distinguish between who's within and who's outside. So the industrial court, in a case of a dismissal for misconduct, regardless of whether you're within the scope or not, the court will still view it from whether the dismissal was with just cause or excuse. So unfortunately, the equalizer at the industrial court makes the domestic inquiry process the standard expectation, regardless of whether you're within the scope of the act or not. So I guess to answer your question, I wouldn't suggest you have a different process depending on whether a person is within the act or not. I will tell you where that could be, possibly where there could be the legal distinction becoming real. If the employee decides to file the complaint with the labor department, okay? So please excuse me if this is a little bit legally technical. Supra, you will understand it. I hope I'm not overly simplifying this. See, the Industrial Relations Act, I think everyone understands. You file a complaint under Section 20, you are asking for reinstatement. We all know most of the time we don't want, the employee doesn't want reinstatement. But leaving that aside, the law states you're seeking reinstatement. For an employee who comes within the scope of the Employment Act, who, let's say, he understands clearly the Industrial Relations Act is reinstatement, and I do not want reinstatement. But I feel I've been dismissed for misconduct unfairly. And as you know, if you dismiss someone for misconduct after a DI, for example, you will terminate without notice, no annual leave is paid. So this guy basically says, I want three things. I want salary in lieu of notice. I don't want reinstatement. I want salary in lieu of notice. I want my annual leave, and I want my termination benefits under the Employment Act. And so, because I come from within the scope of the Employment Act, I bring my action in Jabatan Tenaga Kerja, not Jabatan Perhubungan Perusahaan, because I don't want reinstatement. So here, someone could argue, if let's say the guy is outside the scope, I will say, hey, Section 14 doesn't apply. So I don't even have to follow due inquiry. Whereas somebody who's within the scope, they can say, no, Section 4. Because the Labor Department also hears claims for those up to 5,000, even though you're outside the scope. So that's the part I was getting a bit technical. I don't want to go there. I hope I've answered that. Let me just say again, I wouldn't make a distinction whether you come within the scope or not. Misconduct, the accepted practice is domestic inquiry. However, as I'm sure later when you delve in further, it doesn't mean that if you don't have it, you are dead in the water, but we'll talk about that later.
Okay. Also, not to confuse all the participants, right? The reason I asked the question is I feel it's very important for us to have an in-depth understanding before we start applying. Okay. So as a baseline, we accept the fact that we need to conduct some kind of an internal inquiry process, okay, to establish the facts of the case, right? So this comes to the next question with regards to the golden rule. The golden rule that it is important to give the employee an opportunity to defend and to be heard in a domestic inquiry, right? So could you elaborate further on the golden rule?
Okay. So as we spoke just now, the root, in my opinion, is the need to be fair. So if you look from a legal perspective, that phrase that they always use is natural justice, right? So to me, I wouldn't say that if you have a domestic inquiry, definitely there has been natural justice, because an interpretation of natural justice would become necessary. And as you mentioned, in some cases it may not be even uh, possible for an employer to comply with the absolute best practice of a domestic inquiry. Doesn't mean in that case so there has been no natural justice, right? But I know it's a vague answer, but the golden rule is you have to encompass the principles of fairness in that process. And even if you don't follow strictly some parts of it, but if the essence of fairness is there and demonstrable if you are in court, you should be okay.
So by conducting the domestic inquiry, I am deemed to have been fair to the employee. Lah. Can I assume that?
I wish you could, but no, there is no such deeming provision. So even if you have a DI, the employee can challenge the dismissal. And if it goes to the court, it doesn't mean that the court will say, wait, hang on a minute, there is a DI here. So therefore, I am now going to presume that you're guilty. You therefore prove to me you're not guilty. No. The court will still say, DI ke, tak ada DI ke, burden of proof is still on employer. Please demonstrate just cause or excuse. And as you will find out, telling the judge, Yang Arif, here are my DI minutes, which I painstakingly recorded word for word. The judge still has the power to say, thank you, but I'm not going to just accept the DI. So you potentially have to, most likely have to re-establish that the employee did in fact commit the misconduct in court. And you can't do it by just submitting your minutes of the DI.
Okay. Thanks, Daman. I'm just going to make your life a bit more difficult as we are only, a quarter way through things, right? Isn't the show cause letter a form of DI as we are really giving the employee, we're making an allegation, we're giving him a chance to explain, right? So after the show cause, do I need to do a DI some more?
Okay, so let's delve a little bit deeper there. So if you look at the Employment Act, as you mentioned, it uses due inquiry.
Mhm.
So we should ask ourselves, what does due inquiry mean? Because that's actually the word in the words in the law, right?
Mhm.
Unfortunately, through practice, that due has disappeared and been replaced with domestic. Okay, but if you read the act only uses due inquiry. Okay, so due inquiry simply means an inquiry which is appropriate lah. What is due, right? So I guess if it's a more serious misconduct, more will be needed to show that there is an inquiry, right? Like
Mhm.
I guess if it's a warning letter that you're going to issue, what is due in that case will be less, one would suggest, rather than if I'm going to dismiss, what would be due would be a higher form of inquiry. So you need to understand even due inquiry has fluidity in its definition, and that's where we all that's why we're set up to fail to begin with. Okay, there isn't a clear definition. How nice it will be. Due inquiry means 1, 2, 3, and then we just tick the boxes in jalan, but it isn't. Okay, and I should be thankful it isn't, because that actually gives me my income. So what you call it, I would say that since we understand the word due inquiry is meaning the inquiry that is appropriate, I would say the show cause is one step of due inquiry, right? And I would say that domestic inquiry is another step of due inquiry. So in a case of a misconduct which could lead to a dismissal, one would say what is due there is higher, right? So you possibly will have to do the show cause followed by a domestic inquiry and so on. So, I know I'm giving you not a very clear answer. The reality is, in some cases, in a very minor misconduct, a show cause is enough for due inquiry. A show cause and a
Mhm.
reply is enough for a due inquiry, and you go with a warning. because what is due in that case to inquire is enough relative to the warning, the punishment. But in another case, that would not be enough for due inquiry. If I'm going to sack him, give him a letter, ask him, okay, you stole money from the company. What is your answer? No, I didn't. I don't accept. You are dismissed. That is not sufficient, lah. For a dismissal, right? So you got to be a little bit fluid there, I guess, lah.
What happens if
Uh,
he pleads guilty?
to me, I would say that the whole purpose of due inquiry has been resolved if there is a plea of guilty. There's nothing to inquire anymore, right? Because the perpetrator has said, I did it. Only caution is that plea of guilt must be free of any duress, coercion, forcing up, right? But I know of some clients, even with the admission, they still go for a domestic inquiry. They want to seem whiter than white. So, okay, let's let him go before 3 panels and admit guilt again, so that there is no cause for saying, hey, you were forced into admitting.
Okay, thank you. Yeah, but in this case, I feel like when you're conducting the DI, we are just creating more work for the organization, and this whole thing is time consuming, but business has got to run, right? So when someone pleads guilty and if it warrants dismissal for theft, is a dismissal issue, right? I think we should be able to proceed with dismissal, instead of trying to do a whole domestic inquiry process. Okay, but that's just
Um,
basically my opinion.
but I'm in agreement with you. I'm in agreement with you. I just guess that we don't want to let the participants sort of think that if you do that, it doesn't mean that the employee can't sue you. And typically, if they do sue you, they will claim I was forced to admit. My boss told me if you don't write this letter admitting, I will sack you. Whether it's true or not, the court will have to decide.
Okay, now let's go take DI a step further. Okay, there are cases in court, right, that has highlighted the importance of procedural fairness. So when they mean procedural fairness, I'm sure you know, right? But it's about having the domestic inquiry or the due inquiry because it is part of the procedural fairness, right? That you are giving the employee an opportunity to defend himself, right, for the allegation charges against him. And this was highlighted in the case of Dharmalingam, similar name, Dharmalingam versus Malayan breweries. Okay. Then a contradicting award, which stated the absence of DI, okay, is not fatal in the case of Milan Auto versus Wong Sen Yen, right? So if it is not mandatory as per some case award dictates, then why do we have to bother with DI? As I believe, the industrial court is going to hear the whole case all over again to justify the just cause and also whether the punishment commensurate with the wrongdoing.
That right there is the conundrum, Supra. I mean, you see, I would agree with you that, or rather, it is my opinion that the correct view is the one in Milan Auto, and the courts have agreed with that. So, the natural conclusion of Milan Auto would be, so what's the value of a DI, right? And as you rightly pointed out, a domestic inquiry will take a fair amount of effort, a fair amount of time, right? And taking you away from your normal duties, and people are doing things that they've never done before. So what maybe you could do in 4 hours, somebody may take 5 days, 10 days, and they may make wrong decisions, right? Because when a lot of companies, especially the smaller ones, have a domestic inquiry, the panel members haven't a clue. They haven't heard of the word domestic inquiry, but suddenly they made panel members. So much of effort, all of that, but then the output also cannot be so good, right? Because these guys are not experts. So all of that would suggest, and now you tell me the law says even without a DI, no problem. So the question then is, why do a DI at all? I would agree that it has, because of the decision that you mentioned, the value of having a DI is diminished. But I wouldn't say it is zero. And I'll give you two main reasons for that, in my opinion. The first reason, and it's the easier one to explain, is in the event you end up in court, a good employee lawyer will argue or will put it to the court to say, you see, Young Arif, as demonstration of how quick the company was to decide on my client's so-called involvement in this misconduct, they decided to circumvent the time accepted principles of domestic inquiry and due inquiry, and that is evidence of mala fide, bad faith. What prejudice is there for them to conduct the domestic inquiry before dismissing? I will tell you what prejudice, Young Arif. The prejudice is this: my client would have been found not guilty, and they didn't want to risk it, and hence they dismissed. Okay. Now, can a company turn around and say, Young Arif, you see, because of Milan Auto, I see no value in doing a domestic inquiry. That's why I didn't do the domestic inquiry. Now, if you're the judge, you're going to think, hey, yo, I cannot accept that. So, I guess the reason I'm talking about the value of the DI there is a judge is probably going to be more, you get more brownie points in court as an employer. You can defend, nobody can say that you were so focused on dismissing that you decided to circumvent, so those arguments don't crop up. So that's one value. But perhaps the greater value could be this, Supra. You see, if you look at section 20 of the Industrial Relations Act, the wordings of the act is that where a workman considers that his dismissal is without just cause. So the trigger point for someone to file a complaint is if he feels, he considers, he perceives that he was dismissed unfairly. So I would suggest that if the employee was subjected through a DI, which was done properly, and through that forum, even the employee sort of like, yeah lah, they caught me lah, I got done lah. I think the perception of the employee is that, it's fair, I got done. So there's a possibility, I guess what I'm saying is there's a possibility that a DI could lead to an employee accepting the dismissal without challenging, and hence the company does away with the hassle of going through this entire litigation process. Maybe those are the two values, but I would, from a pure technical legal, if you ask me what's the value of a DI, I will have to say not much.
But still, you would recommend that we have a DI, especially if you will get a lawyer who is going to start finding fault, right, on the issue, okay, based on the fact that we didn't conduct the DI and we have acted not in the best interest of the employee.
I certainly would recommend it. But again, I also want to say that even if you have a DI, it doesn't stop from the lawyer from saying, who is the panel member? What is the back? So you buat pun kena, tak buat pun kena, right? So I guess there isn't a silver bullet lah, but it's easier. Me as an employer's lawyer, I would say I would like the fact that the facts show that the company had conducted domestic inquiry. I would be more comfortable with that rather than without.
So that's the purpose of today, that we are, by end of this session, we're going to find a solution on how we can do a modified, that's why I said adopt and adapt, right? A modified version of a DI, you know what, that will hold water in court instead of me wasting, 2 weeks just preparing for the DI.
So it may not be a silver bullet, but it's a copper bullet lah.
Yeah. Okay, let's get to the nitty-gritty a little bit. Okay, just briefly, could you just share with us the guidelines of conducting a DI? Okay, what must you have? We'll go into the details as we are going along, right? But just to open people's minds, say, okay, DI, what are the key 4, 5, 6 guidelines that we have?
Okay. And I want to sort of start from what you asked about this now. You talked about why, right? Why? I want everybody to understand the why, so that, because when you understand the why, and let me demonstrate why I'm saying this, yeah? When you understand the why, it almost becomes automatic. If you understand it well and you want to do it in a way to achieve what you've understood the why. Does that make sense, Ubra? Okay.
Yep,
So we
yep.
said why? Why? Because it's fair. Okay. And I think the phrase that everyone uses, natural justice, right? Let's ask ourselves, what does natural justice mean? It means what is naturally fair. What would naturally be fair? So let me try to explain that by giving you an example. Okay, I know you have a son. So if Jonah comes to you crying, right, and let's say he says your maid slapped him, okay?
Mhm.
Now, how would you deal with that situation, Supra? What would you do?
I'll have to investigate. Firstly, did she slap him? Okay, got to establish that fact. And secondly, got to establish what triggered the slap. What did he do? Right? Even though the slap is a slap and that is wrong, right? But you also want
So
to
how would you?
understand what did he do. So
Brilliant.
you got to
So
hear his
how would
side
you
of
do
the
that?
story. You hear his side of the
And
story. You hear her side of the story. Maybe check my CCTV.
so you see, that answer that you gave didn't come from a based on section 14, based on section 20. It came naturally to you, right? It came that, I need to find out lah. I need to find out. Now, at the end of the day, if you had CCTV, you might know whether the slap happened or not, but you won't know what triggered the slap. That one is going to be a discretion you're going to exercise. But at least
Yep.
you're taking the steps to what is natural in this. It's not that you must be a rocket scientist or a lawyer with 25 years to think of this. It is just natural. And that really is, I think, we need to understand that, because it's natural. You can't box it up, right? But a lot of what you said is really the guidance, the guidelines you talked about. You will investigate, was there a slap? Okay, we don't even know, right? Because now your Jonah has told you that you have very good reason to believe, because he was crying, maybe you saw red cheeks, but you still want to establish that. Okay, then you want to go into, so let's try and make that a little bit legalistic. So legalistic there would mean verification of the facts. Do not go into a domestic inquiry where you haven't. You see, if you go and charge someone for theft and someone comes in and they show that there was nothing stolen, you know how silly that looks. So you charge someone, you stole the computer, but then he comes to the DA and say, but the computer is there, what? So because there's no verification. So you must have some level of verification that there is something wrong which happened. Okay, what you talked
Mhm.
about, the other principle, you will listen to your maid, you'll give an opportunity to your maid to explain. That has to be weaved into your domestic inquiry process. Why? Because it's only naturally right to hear her before you pass judgment on her, right? So that's the starting point. It's just natural. Okay, so it's all about fairness. So if you think about what would be fair from a legal, if I put my legal hat, if you're going to call your maid, right, make it even better, more fair, you can tell your maid why you're calling her. I'm calling you because there has been someone, Jonah has mentioned, that you slapped him today at 3:35. So she's more prepared than she isn't, right? So that's really fair. So i.e. There's no blindsiding lah. Okay, they're not blindsided by these things. Telling her what she's alleged to have done. You can't say, I want to hear you, you did something wrong. Tell me what you did or why you did it. She's going to think, what did I do wrong? Right? So you identified, you slapped Jonah at 3:35. Right? So the more ability for her to be prepared, the openness that you have in your platform just now, which you talk, your own platform, what you talked about in that situation, you're going to listen to her. Right? You're going to hear her. You're not going to just listen to Jonah and decide. These are the guidelines. Of course, further guidelines, again, coming from a representation perspective, you got to document all of this. Because you got to demonstrate later in court you did this and so on. Right? So I guess roughly just some points there, clarity on what the charges are, a fair opportunity for them to be heard, time to be prepared. This it's not even rocket science. It's not some heavy technical legal rules.
I think the reason being because, I've been in HR, right? And also I've been mixing around with people like you. That is why I do the questioning first. Right?
Very good.
But there could be situations where people actually just jump the gun and, don't investigate the matter, right?
Absolutely.
Okay. So
Absolutely.
before you have given the fundamentals of or the guidelines, yeah, okay, what we must have, okay. Now we take a step back, right? The pre-documentation that entails prior to a DI is actually conducted, right? We talk about, say, when a misconduct happens, you will start with obviously a show cause letter, okay? And you will have made the allegation against the employee for one misconduct or two or three misconducts, right? Act of misconduct. And you use the word allegation there, right?
Hmm. Hmm.
Then there is an issue where most times people feel that I need to suspend the employee. Okay, immediately follow the law with the Employment Act lah per se says suspension with not more than 14 days with half pay, right? So maybe you could explain more. Is this required? And I would like to go a little bit further later when we talk about the charge sheet, why the terminology of allegation, right, then is converted into charges.
Okay. Okay. But maybe let me start with that last part, Supra, because this is my thought on that, right? So, see, the show cause letter, domestic inquiry to me is all the steps in due inquiry. The show cause is sort of an earlier step relative to the domestic inquiry. So at the show cause stage, because it's earlier investigations, you tend to use words like allegations and so on. But if you, from here, after the reply, if you're progressing to a DI, it is indicative that you are a bit more sure that something has happened, right? And so that's when the terminology charge is used.
Okay.
Really, I'm not hung up on this terminology. Okay, you can use allegation both sides. What you don't want to do is, you can't say you are hereby alleged to have committed. You can't say things like you are hereby guilty of the following misconduct, right? So that's the no-fly zone. But between allegation, charge, you know, tomato lah, no difference to me, right? But I think that's why the allegation here, because it's an earlier investigation step compared to DI later, so you're more sure, so you call it a charge. I've forgotten the first question.
Yeah.
What is the first question you asked again? Remember,
The first is regarding the show cause letter, the allegation, okay? And we were talking about the requirement of the law, or it's stated in the law with regards to the suspension
oh yes,
during that.
sorry. Okay, I see you also forgot it for a while.
I had
Okay,
to recall.
okay, you're right. So suspension. Yes, the law provides for those who come within the scope of the Employment Act. The company has a right to suspend an employee, and the suspension can be for 14 days, up to 14 days on half pay. And if that is not enough, you can extend, but it should be with full pay by implication. And also, the law says if later the person is found not guilty, you have to restore the pay. So you have to pay back the. But the question, Supra, you're asking is, so must you suspend? When do you suspend? Why? When do you don't suspend? Okay, so must you suspend? No, it is entirely a discretion of the company. Typically, suspension is used when, number one, mainly you are concerned, the employer is concerned that if you don't suspend the employee can frustrate or interfere with the investigations. It could be, for example, you need to do some data mining on his laptop or his desktop, and if you don't suspend him, he can delete the data, right? Um, so that's one main reason. By not suspending the employee, you feel that it's going to interfere negatively on the investigations. Now, another reason why you might want to consider suspension is it is a case where everybody knows about the case, everybody's talking about it. It involves a very serious case or senior person, and so you just want to calm things down. You know, if the person's still coming into work, everybody is talking, all that rumor mongering. So you feel that it's better to suspend. You can do that, right? So it's not a necessary step that you must suspend every time you issue a show cause. Yeah. I would also like to
Thank
add
you.
as
So,
well. Supra,
yeah.
just one small bit. Sometimes I've had an experience where at the time we issued the show cause, we didn't see any need to suspend. But after the show cause was issued, the employee was unhappy, was starting to behave in a way where they were influencing witnesses and so on. So we suspended subsequently. So there was a
Okay.
case where the company consciously decided no need to suspend, but that exercise of discretion was reviewed because of the behavior of the employee post the receipt of the show cause letter. Right?
Cool. So, to establish the fact here is, okay, suspension is not necessary, but it is something that you have to look into the situation, whether it stops you from conducting your investigation or it affects the morale of your other employees within the organization, because, right? So you could exercise, but you could also exercise suspension with full pay, right? Because at the end of the day, it's safer to do a full pay during show cause because you have not really established the fact whether he's guilty or not.
Yeah,
Correct?
you're right. You have the law allows you to be better than the act, but the act provides. It's a good point. I'd like to just elaborate a bit here, bro. The act provides for suspension on half pay. Now you raise a good point, but you haven't established anything. Why does the law allow you to suspend on half pay? I would like to think that's because the law is assuming the employer, if they're issuing the show cause, they have reason to believe, good reason, reasonable reasoning to suggest the employee must have done it, right? So I think the point I want to make here is the only time you must never use a suspension is do not use a suspension as a mean to demotivate, victimize the employee. I just suspend him, lah, let him, right? So the guy is late 5 minutes, suspend you for 2 weeks. What the hell, lah? Right? So you gotta so you gotta. That's the only time. That's a no-fly zone. right? So don't use suspension as a tool to frustrate the employee.
Cool, thanks. The other part on show cause letter, right? We normally give a timeline for people to respond, and I find, sometimes we go into, okay, I think 3 days is enough. Sometimes I give 5 days. So what's a reasonable amount of time frame, for us to really say, okay, I think this is reasonable enough.
Suprat, today is
Am,
Friday the 13th.
am I
So
guilty too much?
no, obviously the devil in you has come out. You're asking me all these questions which do not have a definitive answer. Okay, but great. I mean, I think this is the whole reason why you're having this webinar, right? You want everyone to think critically and know why you do this rather than robotically follow what you get in a textbook, because this is such a dynamic area of the law. One size doesn't fit all. Okay. Now, my answer to that will be, how complicated are the charges? Okay. So let's say I came in late 45 minutes today, or I was absent without leave for 2 days. Let's ask this very reasonable question. Supra, let's say you didn't turn up Monday and Tuesday. Wednesday, you come into work. Your boss asks you, Supra, why didn't you turn up yesterday and day before? How long do you need to answer that question?
Immediately, I could.
So you see, you give the guy 5 days, he will create five fantastic stories or whatever. But leaving aside that, I said that's the judgment. Sorry. But in an uncomplicated charge like that, do you need 5 days? Do you need 7 days, 1 week, 2 weeks? But likewise, if it's a complicated charge, you are taken trade secrets, you've given it to other people. There's a volume of documents that the company has given to you together with the show cause asking for your explanation. Please give a detailed explanation as to why this transaction happened on the following dates. 85, 95 transactions going back over the last 5 years. Clearly, the guy is going to need more time to answer, right? So, my guide to you is, what would be a fair amount of time for that employee to answer the charges relative to the complexity of the charges, right? But typically, when you talk about a domestic inquiry situation, I've never seen a case of less than 3 working days at the minimum,
Okay.
right? 1 week seems to be the norm, but you might want to give more than 1 week if there are 15 charges, detailed charges, and so on.
The reason for all these questions, I want to establish the baseline, right, at the end of the day. Because, like I said earlier, we tend to attend courses and all that, and people say 3 to 5 days, But I want people to understand at the end of the day, if the issue is not so complex, like what you mentioned, right? I think a 2, 3 day period is sufficient. If like it's complicated, so you need to exercise the element of being reasonable in that
Absolutely.
situation, right? Okay, the next question is, when we are drafting the allegation, this is some things I've also encountered. We have drafted it, and sometimes it has gone to court and it backfired. Okay, it's like, I am alleging an employee, you have breached the company policy and procedure relating to the approval of payment vouchers. Okay, of the payment vouchers. Okay, that's one form of an allegation made. Okay, then over these years, we have realized that that's insufficient. Okay, we should be drafting like, on the 23rd of January 2015, you had approved payment voucher number 12455, dated 21st of January 2015, voucher bracket. The voucher was for payment sum of 15,000 to a company called ABC Cinema for the purchase of this. Yeah. So then we realized, oh my God, the allegation is that right now is something drafted in a way that we probably need a diamond to come in to draft for us, man. Right? So This two disparity, would it be very crucial when the
Okay.
issue goes to court?
Okay. So, again, to me, I think the reason we have that issue is because of the development of the law. Kudos to all the employee lawyers in the past and MTUC in the past who've pushed so hard in courts that the courts have raised the bar in terms of expectation. But from a legal perspective, if you go back to natural justice, you look back at the principles of natural justice, right? The requirement really is, does the employee understand the allegations made against the employee? So I guess, are there enough details and information for the employee to understand and satisfactorily prepare a defense for himself? So you need to provide as much details to satisfy that threshold. But I would suggest you need to be mindful that for more complicated allegations, and for senior level, you probably need to be more detailed, right? Because for complicated charges, you need to the employee. You don't want to be in a situation where the employee is saying, "So what exactly did I do wrong here?" You need to call out that wrong. So if there's a very detailed SOP and so on, right? So where is that wrong needs to be identified. And if, for example, say I'm doing 350 approvals every day, and you said that I've made 4 questionable approvals in the last 9 months, you need to identify lah, because otherwise I'm looking for a needle in a haystack. How am I going to defend? I do 300 approvals a day. You said in the last 6 months I made 4 wrong ones, and you don't tell me when, for what items. So you need to include as many details that you would need for the person to understand exactly what the charges are and for him to be prepared sufficiently.
So the key is in the detail, right? It's not that I have to be a Daman Sivalingam, lah, right?
No, not the language.
Okay. Okay, that's very good. Okay.
Mm.
The next question is from employees not happy. So I'm kind of taking you through the process, right? From the show cause right now, has replied to the show cause, employer finds unacceptable. Of course, when they find it acceptable, they would say, okay, your explanation is satisfactory, so therefore there's nothing done, right? So in a case where it's unsatisfactory, then they decide, okay, now is the question, okay, I'm not satisfied, why? And do I go with, I think he's guilty, so I think I better fire him because as an employee, I feel he's guilty. Or I say, take a step backward, let's do a domestic inquiry and let's put together a panel and the process and give him a chance. So I, as the employer, take a step backward and just hear a group of independent guys, not really independent employees or whoever, right? But at least they are not involved in the case or the matter, to then deliberate and advise the company that whether he's guilty of the offense, right? And give me some recommendation, right? That's why we feel a DI is required, right? Is to give him a chance to be heard, and also is to take the employer a step backward, right? So you don't act out of frustration and emotion, give yourself a bit of time to think as well, right? So in the charge process, right? So you explain that the changes of the allegation to the charges. So if I do my charge sheet, but I call it allegation, is it wrong?
I wouldn't say it's fatal. It comes down to the same thing. Here is what I'm alleging you have breached, or here is what I'm charging you with breach. Right? So I wouldn't, I'd say it's a distinction without difference.
So meaning I have gone to another level that I am a bit more certain that you have committed the act of misconduct right now.
Yeah, I think that's the thinking process. That's why
Okay.
the language seems to change.
Mhm.
So it's one would imagine the further you progress in investigations, the more sure you should be, or the more evidence you should collate lah.
Mm. Then, in terms of the timing for me to call the employee for a domestic query, that's another. See, we spoke about the reply, now domestic inquiry. Can I call the guy, say, give him 2 days notice for a DI, or do I give him 1 week notice for a DI? Given
Yeah,
that I've already given him time to show cause.
agreed. Again, no precise definition. So you need to work off what we think might be reasonable. So I guess there's a slight difference. I mean, not a slight. There's a significant difference between the show cause stage and the DI stage. The show cause
Mhm.
is you're going to write it on your own or with the help of someone outside. But in a DI, you're going to be in a meeting, right?
Mhm.
Essentially, it's a forum, it's a meeting of some sort. And without before the COVID days, it's all done face to face. You're going to be there. There's X number of people. So it's fair to say that it's more daunting attending a DI than it would be replying to a show cause. So on that premise, possibly more time is fair for the
Mhm.
employee to be better prepared to
Mhm.
understand a little bit more, I guess. And I think that's the thinking behind why you need to give a bit more time to a domestic inquiry. But the reality is, Supra, you give the 2 weeks. So where is the guy going to get that information from? If you talk of a factory worker, right? You don't think, I mean, I don't think he's going to do a research or ask the HR, okay, tell me what happens in a DI and so on. But anyway, the accepted norm seems to be a minimum of 7 days a week and 14 days, but that's the reasoning I would imagine.
Okay. Thank you, sir. And now let's get to DI. So when you conduct a DI, you need panel members. Could be one or three, and better to have three, right? One chairman, two panel members. Then you have got IO, investigating officer. Then you have got PO, prosecuting officer. Then you have got secretary, right? Then you've got a tape recorder to record the conversation, right? So could you walk us through this and explain, what? So every time I conduct a domestic inquiry, must I have this full fleet in a DI, right?
Okay, so again, Supra, I would have to put that down to the development of the law, right? So the development of the law and what seems to repeat in the industrial court over the years is that three panel members and so on, but that's not written anywhere in the law. So I guess that's the best practice. Yeah, but
Mm-hmm.
the best practice is not the only practice to deliver what is needed lah. But
Mm-hmm.
obviously, Supra, I would like to caution anything I say now the fact that the more you deviate from the best practice, the more you need to spend time convincing the judge that it may be a deviation, but there's no compromise in the principles, which I think you should
Mm-hmm.
be able to do, right? But the more you deviate, you need to make sure, you need to understand, you need to do a little bit more in court, right? Because there's no question, hey, only one panel member, right? So best practice is sort of accepted. But if you look at the law, it's basically, it states you must have an unbiased decision maker. That's the requirement. The requirement, if you follow the principles of natural justice,
Mm-hmm.
unbiased decision maker slash makers. So the decision of whether the person is guilty or not must be made by someone who's unbiased. There isn't an indication of one, two, three, four. I guess one would argue three people deliberating should come up with a more qualitative answer compared to one person lah.
Mm-hmm.
Right? So again, that's best practice. But then if you have one very smart person, he probably can do a job better than three people. But what I would say is that these are the best practices that you mentioned. You talk about three-man panel. But so long as the requirement that an unbiased assessment has been made, you are not in breach of natural justice, as the way I see it.
Okay. But must the panel be internal members of the company employees, or could I bring people from outside to become panel members?
Um, it should be internal. Now,
Mhm.
so the reasoning behind that is, I mean, it's domestic, right? Domestic inquiry. So it's people from within. So the panel members, in the absence of a reason, an acceptable reason why you couldn't identify internal people, I would be slow to advise you to get external panel. But you can, in the given circumstances, right, where it's
Mhm.
impossible for one reason or the other.
Okay. So in the case of a prosecuting officer and investigating officer, could it be the same person doing the job, or it must be clearly defined and they are two separate functions?
Again, I'm not. It's not a legal issue there, but I guess where in some companies where they have a investigating officer and a prosecuting officer, it's possibly the large organizations where the volume of work is so much that it makes sense to divide the investigation into one department and the prosecution into another. But ordinarily, to me, it would be sensible that the person who investigates does the prosecution, because a prosecutor who's not conversant with the evidence is not going to be a very good prosecutor, right? But again, so these are like, you talk of absolute best practice, yeah lah. You look at like how the police do it. So the police will investigate, but the DPP will prosecute. But that's because there's a machinery and arm of the government that's doing that, right?
That's the
Because of the
full-time
volume.
job.
Yes, that's right.
So we're going to take from here, right? Going to ask a few quick questions before we go into the case study, right? Can an employee bring his lawyer into the DI?
You could say no. I mean, you have the right to say no. Legally, it's your right to say no. But again, you see now. Earlier, remember we talked about what if the company brings in an external party,
Yeah.
right? Then, on what basis are you saying no? Earlier, you say domestic. That's why it's internal. But you bring external, can you know? So that's where you got to be careful.
Because in some situations, a company would have their own legal counsel, so they decide to bring their legal counsel, right?
In-house legal counsel is
Mhm.
still domestic.
Okay.
But you're right, you've identified an uneven playing field. So in a large company where you have a general counsel, in-house
Yeah.
head of legal, and if he becomes a prosecution,
Mm.
one would argue that he's going to be a lot more suited for that job compared to the employee. Yeah, but
Mm.
you see, the employee can be represented by someone internal if
That's
someone is willing
provided
to.
and unionized, lah.
Even if you're not unionized, right? Because it's
Mm.
domestic, the guy says, "Hey, listen, so and so wants to represent me."
Mm.
That's going to be difficult for the company to say no because it's still internal, and the company, whoever who's doing the prosecution, is representing the company anyway. It's not external.
Okay. So now we're going to go to the next part of it. We're going to go into a case study discussion. Okay. As I think a lot of people have gone through and studied and done a lot of seminars on domestic inquiry. You got to have the panel members, you got the whole process, the whole engine. The case study today that will one say, given a scenario, right? I'm a small business with a 15-man operation, okay, and I've got a serious issue of misconduct, okay. Talk about a theft issue, right? I've done my show cause, I've done my charge sheet. I'm going to conduct a domestic inquiry. So would you be able to walk me through how do I actually conduct a domestic inquiry, okay, in this scenario? scenario where I'm a 15-man operation. By the time I put 3 panel member, then PO and IO and 70% of my employees are working on this,
Right.
right? So how do we come up with a workable solution here?
It's a tough one in terms of if you want to comply with best practices. I think it's impossible. But the law
Mhm.
doesn't make best practice a mandatory requirement. Okay, so let's see what we could do. Of course, again, I want to caution by saying that when you don't follow the accepted norm, you need to explain it in court, or it will be questioned in court, and we need to have a justification. The justification would be 15 man, so on and so forth. How do you expect us to do this? Okay, so
Mhm.
if you look at the building blocks
Mhm.
of what is required is natural justice. Natural justice talks about someone who is the person to be judged by an unbiased decision maker, fair opportunity being given, i.e., the person should have details of the allegations, should be able to question witnesses of the company, should be able to provide his testimony, his evidence, right? These are the type of requirements that you're talking about. So we want to be able to replicate, or sorry, not replicate, to meet the elements of natural justice in the sort of confined area of a small organization like what you mentioned. Okay, so if you've got 15 people,
Mhm.
what the first thing you want to do is, of course, go with the show cause letter, right? So you draft the show cause letter, identifying clearly what is the allegation of misconduct, and wait for the response,
Mhm.
right? Along the way, you gather whatever other evidence you may have, CCTV evidence, or you're speaking to other witnesses. For example, you might have a security guard, or you might have a receptionist who saw this person leave or enter suspiciously. So you're doing all of that at the same time, and then you get the reply. Of course, if the reply is an admission, yes, I did it, I'm sorry, I would suggest close and decide on punishment straight away. Yep, no further steps needed. But if the reply is a denial, so now you've got to think about having that platform to meet the requirements of natural justice law, right? And based on 15 people with in the company, I don't think we can meet the best practices. Very quickly, what are the best practices? 3-man panel members. The 3-man panel members are people who have got no knowledge whatsoever of the case, people who have got no ill will against the employee, right? Then you have one prosecuting officer. You're probably going to have a few witnesses. The accused is going to be there. You're going to have somebody to take down minutes. The whole company is going to stop for this process. Lah. But even then, right, would you even have 3 people who don't have knowledge about the facts of the case? You may not. In a small company, everybody may know about the theft, right? Because it's such a huge issue. So then what do you do? What I would suggest is you could consider an external panel member, right? What do I mean by an external panel member? You could get your you could get lawyers, you could get consultants, you could get your company secretary, anyone who has got an ability to reasonably decide based on facts with no prejudice. I would also say now, but does it make sense for you to incur costs for this? What if you can't? You're not inclined to incur costs in this kind of difficult situation, and so you somebody who's going to decide on that process is someone who knows the facts of the case. That person needs to be conscious that when he's exercising that duty, he needs to do it in an unbiased manner. Now, how do you demonstrate that? I don't know, lah. Right? The witness will have to come to court and so on. But I guess you could do it with someone who may have full knowledge of the facts of the case, but who can still decide, I'm going to be unbiased in my approach. I'm going to listen with an open mind and make an informed decision. Yeah. Now, what about the prosecuting officer? Who's going to be the prosecuting officer? Do we need to have it like what we see, what you might have in your mind in a DI? It's like in court, one person on this side calling the witnesses and so on. Now, in this kind of a situation where that is not possible, I would recommend you could even call it, run it like it's a meeting, right? So you have got the chairman is somebody who's the lead of who's going to be the leader of that meeting. You have got somebody who is going to present the evidence for the company. It could be more of a dialogue kind of a situation. Of course, if this is being recorded, we can record it. And the accused employee is there. If you have any witnesses, the witnesses come in at the time to give whatever information that they may or may not have. The chairperson can probe and ask questions. They can, to get more clarification. In this kind of a situation, I would also suggest that the chairperson might have to play a bigger role. They may have to assist the employee a little bit more, right? Because the employee may not be able to ask the right question. So you're literally running it like a meeting, Supra, and it's minuted like a meeting, right? Yes, is the guy unbiased? I can't demonstrate that. In fact, I know he knows about the facts of the case, but I can tell you that no one in the company doesn't know about the facts of the case. So hence I've decided to go with him, right? And if the evidence is presented in a way which leads to the conclusion that any reasonable person would say, yes, he's guilty, I think you have to be strong enough to make that call. But likewise, if that evidence is not there, you must be fair enough to say not guilty. Yeah. So, and you've got to minute that down. So I would suggest it's going to be basically the chairman might be the owner of the company, right? His admin head is going to be the prosecuting officer. What does that mean? It's not going to be done in court. Exhibit A, Exhibit B. It's not going to be like that. It's going to be, imagine this. Okay, Miss T, my admin, Miss Chi or whatever, my admin person. Now, what is this issue here? Tell me what happened. Okay, boss, yesterday, the security guard informed me that Mr. A took this package. What is that package? So you're just asking questions like a normal meeting, right? But in that process, you must allow the accused employee to ask questions from the security guard. You must allow the accused employee to look at any documents that you have and allow him to frame questions based on that. At some point, as the business owner will also have to say, okay, what do you have to say? You've heard of all of this. What is your story? Have you got any witness to help us understand where you were? That because if your story is you were not there, where were you? Were you with someone else? Is there anybody else? Were you with? If you were with Ali, come, let's call Ali. Okay, let's call Ali. Call Ali into the room. Do it like that, and document the whole thing, lah.
Okay. So the documentation has still got to be done word for word, lah. Okay.
I would suggest that, lah.
What happens if, I'm willing to spend the money and say, I get my accountant, I get my company secretary, and we get one of my vendors or suppliers, okay, put together, and and conduct the DI from that perspective. Even though it can be said that they don't have direct dealing or biasness on the matter, but if I am the employee's lawyer, I would probably be arguing from the fact that, the company has got a certain control when they appoint their lawyers or their accountants or their vendors, right? So that influence that they have would have pushed that panel to make a decision that the employee is guilty. So therefore, we are of the opinion, even though they got that external party, they are still biased. How do we address a situation like that?
Okay, so where would that argument come up? The argument would come up, number one, the employee at the DI may say that. Right? So the DI comes in and he says, excuse me, Mr. HR, I don't know who this person is. Who is this person? Who's this person? The company secretary. So appointed by you all. Sure, unfair one. Right? So you have that objection. You got to deal with that objection there. Right? Now, how do you deal with the objection? But the only way you can deal with the objection is you can only give an assurance that yes, I have been appointed by the company, but my brief of the appointment is to make an objective assessment based on the evidence that I will hear, and I will be hearing your own statement as well. And I guess that if you feel that you cannot trust me, we have to agree to disagree and proceed. But I am going to try to be fair. What else can you do? The other aspect where it may be challenged is if it's in court. But in court, again, remember you talked about Milanoto. So if you chuck, most likely the whole DI will be chucked out anyway. So even if you brought the most sharpest legal mind in the world, you brought one judge from UK and paid him £20,000 to be a chairman, right? It's still probably not going to be. You're going to go
But
through the
at
whole
least
process.
I would meet the procedural fairness side of the matter,
Yes.
okay? And I've gone through that because, in my opinion, I think it is not about conducting the DI, but it is having the DI so you can really establish that the person is guilty and you've got all the evidence, you've got witnesses, right, to point to the fact that he's guilty. So you're not
Mm.
just doing it for the procedural fairness side of it, right?
Yes. Yeah. I mean, that should
So
be the
if
way.
you are doing it, yeah, so if you're doing it from that perspective, so therefore you have, as a company, say, I'm small, I've got 15-man operation, right? I can't put my employees, right? Because even if I put my employees, they might say that this is wrong, that is wrong. They always find fault, right? So I right now try to put together a
Mm.
panel who are associates, okay, and got them involved. And I believe that my panel, who are lawyers and accountants and all that, even though I've got certain influence over them, but they are independent bodies or independent parties, okay,
Yep.
that I can't just simply bully them into being biased towards the organization, right? That is why you've got accountant, company sects and all that, because you as a company have got to comply to certain requirements. So given in a small business environment, so I could organize DIs of this kind of nature, right? And get it recorded, and it will be technically still acceptable in court.
There's
Can
a
we say
potential.
that?
There's a potential. There's a
Mm,
potential.
mm,
I'm not saying that the court will automatically say no,
mhm.
but I think it's very likely that the court will say, never mind, let's err on the side of caution and you demonstrate to me in court whether he's guilty or not.
Mhm. But would you say it's a good practice to have it? Or would you say in a situation like that, I don't hold a DI?
No, I would say it's definitely good practice. I just want to manage the participants' expectations that that doesn't mean you will definitely succeed in court. I want to just be very clear about that.
Mhm.
Because with the best of DIs, there still is a likelihood that the court will say, never mind, reset button, demonstrate in court again.
So the key here is, don't use domestic inquiry as a means to a termination, a dismissal, right?
Absolutely.
So use the domestic inquiry as part of your internal disciplinary process, okay, to establish the facts whether the employee is guilty, right, or not, and
Correct.
whether the offense is severe enough for it to warrant a punishment of dismissal.
In fact, that one, Supra, we don't do that at the DI. DI is just purely, are you guilty? right? If the panel
Okay,
decides guilty, then HR decides with management what's the punishment.
but in some situation, I have seen that the panel actually gives recommendation.
Yeah, I've seen that. I am strongly against that practice. The
Mm-hmm.
reason being, if you look at the definition of, if you look at the principles of natural justice,
Mm-hmm.
the panel members should not have any biasness against the employee, right? So therefore, if the employee has got previous records of warnings and misconducts or whatever, the panel member should not know about it because that's irrelevant to this
Mm-hmm.
case, right? So they
Yeah.
wouldn't have sight of that. And so they may recommend a punishment without knowing that this guy has got 3 warnings in the past, he's had a suspension with no pay in the past, and this is now he's doing this again. So then it looks like, and let's say the panel members go, I will go with a warning, but a company dismisses. You have this issue of having to explain to the court, hey, why panel said only warning, you go and dismiss. So I would encourage companies to ask confine panel members to making a decision on guilt or otherwise only.
Okay. Cool. So we can do a DI with external parties, put it together, okay, and try to keep the panel, okay, from away from trying to make the decision with regards to the punishment, right? Just focus on establishing the fact whether he's guilty or not guilty, right?
Yeah.
So that would give a possible solution for the smaller companies, right? That at least I can do. This is probably what I will call a due inquiry.
Mm.
That means I'm having a small inquiry session or investigation session to establish all the facts before I do anything further, right? Instead of worrying about trying to put together, okay, I'm going to have a domestic inquiry and it's got to be prepared and have got to have the panel members and all that. But in a larger organization, I assume you can do that. But in a smaller
Correct.
environment, you can't, right? Okay, what happens in a situation if, say, uh, I've organized the DI, the employee doesn't turn up for the DI?
Good question. Okay, firstly, I hope you're not making sending text messages to your girlfriends. We can see you
No,
texting.
I'm reading questions that is coming in.
I know. I'm joking. Okay, so the if an employee doesn't turn up, typically we always advise uh, I would advise companies to state in the notice of inquiry that in the event you do not turn up, we will proceed with the domestic inquiry ex parte. Ex parte means in your absence. Now, what does that mean? That means the guy most likely is going to be found guilty because the panel is going to be hearing one side of the story, only the company's prosecution side. But I would suggest if the person didn't turn up, don't straight away proceed. You know, try to get a hold of the employee to understand why the person didn't turn up. So if the person has a justifiable reason, I mean, let's talk about if you met with an accident on the way to attending the DI, for example, then you shouldn't proceed with the DI. But if the employee either doesn't, is not contactable, refuses to answer your message, or basically says, well, I don't care, like you carry on, like this is your DI, I know you found me guilty already, I don't want to attend, then you proceed in his
Okay.
absence, and the decision will be binding on him.
That's good advice you've given. In the event he has some excuses or reason, okay, that is reasonable, then we set another date, right?
Correct.
And if it's unreasonable, okay, that he doesn't want to attend, then we should proceed with the DI line, right?
Yep.
Okay, and I think we're talking about the chairman. Okay, if the owner of the company is the chairman, right, and he is part of the panel, okay, he will be making the decision to terminate or not. Does this not meet the procedural fairness if the
You're right.
owner of the company? Ah,
You're right. You see, so if you look at the best practice we talked about, that's a damn good question. We talked about just now. We want the panel to only determine guilt, and then management determine punishment. But here, owner is in the panel. Owner is going to decide guilt here. Then later, owner. This one is like, upper. Who was that who said no? I don't know whether I'm going to get into trouble with this when you talk about Najib being finance minister, Najib being this, Najib Tanisni, Najib. Okay. It's a bit like that, right? So, but I guess, if I come back to what you said just now, Supra, if that is the reality, if I've got a flat organization, let's talk about I run a maid service. I'm a maid provider. Okay, I own the company and I got 14 maids, so 15 of us in the company. 14 maids are all same rank, all report into me. Now, one of the maids has stolen, potentially. I can't put a fellow maid as a panel member because the rank and so on. You typically panel members should be a higher rank, right? And the, there might be pakat between them. Okay, so I have to be chairman. Then after that, when decision is made, when decision is guilty, punishment decision is to be decided. I'm the one who's going to decide, right? So I guess in that situation, I got to explain to the judge. If I'm the lawyer, I'm going to say, Young Arif, is this in line with best practices? No, it isn't. But is best practice possible in the environment that my client finds itself? No, it isn't. So how far wrong is this, given the circumstances that my client finds itself? How is this illegal? What else should my client have done? Right? So you have to do those things. You have to accept procedurally you have not ticked all the boxes, but you are trying to explain to the judge is not because I chose to do it, but because my circumstances were such it's not practicable for me to tick all those boxes.
so technically, you know what, being reasonable here, sometimes we keep talking about this, it's always going against the company. But if the company can prove that it has been very reasonable in the process, I think the company has got a good chance of winning as well, right?
Provided you have a reasonable judge.
You,
I mean,
are you
listen, guys.
saying there are chairmen who are unreasonable?
No, you see, you must. I'm not saying that. Who is to say where you should draw the line? And some chairmen, some chairpersons are a little bit more by inclination, more pro-employee, and they may be right. Maybe that should be the way. But if you have a chairman like that, you're going to have more challenge than you would have in a situation where you have a chairman who tends to find in favor for an employer. Right? I'm not saying the chairman who finds favor employer is less wise, incompetent. Please don't get me wrong. But I think we need to respect that different standards apply even at all court levels.
Okay, next question. Can the employee use the fact that the three panel members have already been briefed before the DI to bring the case into court? So that means it's like the panel members are requested to go into that inquiry, right? And they have been briefed and possibly influenced by the management of the company that, you know what, you better make sure that you make a guilty verdict, okay? So
Hmm.
then I can terminate.
So if there is evidence of that, Supra, a good employee lawyer will bring that up. Of course, don't forget, going back to Milan Otto, that doesn't mean that the decision is automatically wrong. The court will hear it again. But a good employee lawyer will bring that up to say, look at the mala fide in the company. They tried to run a DI to hoodwink Young Arif, to hoodwink this court. But behind the scene, they were puppet master. And the panel members who they try to tell us are unbiased were instructed, Young Arif, to find guilty. They will do all of that. Lah. So now if you're the judge, Supra, you hear that and you got proof, you know what you're thinking? You are already going to think, Mr. Employer, habela kamu. Now I go through, I follow Milan Otto and I ask you to demonstrate. I'm already decided for the employee now.
But that's the problem, right? Because most times you're bringing panels together, right? And not it's not like everybody in the company, the minute you join day one, everybody is straight. Okay, you are head of sales manager, you're an accountant, but part of your KPI is you must have the knowledge on how to conduct a DI or how to be a panel member, right? So the company would, in certain circumstances, say when they appoint the panel, they would brief the panel about, we are appointing you as panel. There's going to be this case. And what's your job and responsibility as a panel, right?
Absolutely. So I think there, Supra, the thing is briefing as opposed to brainwashing, right? So the briefing, I think, is only fair. You are right. If you get any employee who doesn't have a HR background and say, okay, you are going to be a panel member, the first question is, what does that mean? Right? So you need to give some level of briefing.
But you don't brief about the case background, right?
Yeah, you can't go and say, okay, this is the case history. Now, this is what you have to decide. And ultimately, you have to say, yes, guilty. That one cannot. Lah.
But I can brief that this is the background of the case.
No, you shouldn't. You shouldn't. They should find out about the case
On that very day.
On that very day from the documentation. So typically, best practice would dictate. Let's say I always tell my clients, DI to kick off at 10 o'clock. Get panel members in 8:30. Give them the show cause, the reply, the notice of inquiry at 8:30. So that's the first time they're seeing these documents. They're understanding what the facts of the case are. And that's the first time they know that. And the three of them can say, okay, all right, wow, these are the charges. And perhaps they can talk amongst themselves to decide, okay, how shall we approach this? What are we looking for here? That's how it should work. You see, the reason if you give the panel members this information far ahead of time, I believe that human beings by nature are curious animals. So the panel members will do their full-on forensic investigation before the DI. So they come to a DI already decided.
Cool. Because they could be summoned to court, right, as witnesses. So if I'm the lawyer representing the employee and I want to prove that the panel members have been influenced, I can actually call them in to court and say, did you or did you not get this briefing and this information with regards to the case prior to the DI, right? And of course, they can't lie, correct?
Yep, that can happen.
So you can get it.
Yep.
Okay, next question. When do we share the chart sheet with the panel? Okay, I think we kind of addressed that. Okay.
Yep.
Upon issuance of the notice or on the day of the DI, I think we just addressed that question, right?
Yep.
Next, if the accused employee witnesses involving ex-employees, but they are not available to attend DI for the next 6 months due to personal reason, please advise whether it's fair for the DI to continue. Okay, let me read again. Did you get it?
Yeah, I
if
think
the accused employee's witness involving an ex-employee, but they are not available. Okay, so if they can't get the witness not for at least 6 months. Can you postpone the DI for 6 months?
So to me, right? So what is the personal reason that makes it impossible for the person to attend for 6 months? And I think I know we're not talking about this topic now, but the way we're doing the webinar, right? There's nothing to stop a DI from being done this way, right? So really, you can't even come on a platform like this for 6 months. Where are you in jail or something? So right. I think to expect the company to hold the DI for 6 months in the absence of some super concrete reason is not fair, lah. Yeah. So I would think that possibly you need to assess the reason, and I would ask for the proof of the reasoning. Why can't the witness come? Why is it 6 months? If it's a week, 2 weeks, I would accommodate, you know because one of the requirements of, if you talk about the Audi Ultram Partem, those two rules, right? Audi Ultram Partem talks about the accused must be given the opportunity to call his witness, right? Witnesses which are relevant, they must be given must be given an opportunity.
Cool, thank you. Okay, the next question is with regards to the panel, right? Once they finish that whole DI process, okay, this is again going back to how long would you give the panel the time to make a decision whether the employee is guilty or not? And what is the reasonable time frame for you to revert back to the employee or the accused employee?
I would think that you shouldn't delay that more than necessary. It should be as soon as practicable. Again, complexity of charges. Um, I what should happen is the panel members should get into a room together, should debate robustly what they think about each and every charge, why one person says guilty, one person says not guilty, and vote. Um, I think we need to be mindful that if you put yourself in the shoes of the accused employee, it is unfair for that person to be having this hanging on his head for longer than necessary, lah. So to me, you should take within a week. But I know I have got some of my clients, the larger multinationals, they have got many stakeholders, so many stakeholders have to agree to the decision. So sometimes it takes a month in some cases. They need regional to say okay, legal to say okay, regional legal, regional HR, HQ, right? So many layers. Just don't delay it inordinately without a valid reason. That's what I'm saying.
Okay, good. Does the selected panel have to be higher ranked than the accused employee?
Not have to, but I'd like, from a practical perspective, the panel is acting like a judge. That means they are they will be controlling the proceedings. They should be controlling the proceedings. So I think, I trust you can understand for yourself, if it's the accused is more senior than the panel, it's going to be difficult to control that proceedings. Yeah. And then of course the element of victimization and so on. It's not victimization. You belittle someone if they are being judged by someone who is of lower rank, right? So that is why you go with at least same rank or higher.
Thanks. Next question. If the only witness is someone related to the accused person, especially a relative to the accused employee, but the panel is sure that the witness will not be biased, so is the witness still valid?
Okay, the validity of a witness, I wouldn't use the word validity. I think you got to talk about the relevance of the witness. The witness must be giving evidence which is relevant to the charges, relevant to the what the employee is being accused of. Okay, so whether the witness is a relative or not, So long as the relative is coming to give evidence relevant to the charges, you can allow it. Okay, but it's got to be relevant. So, for example, if the accused says, "I want to call my mother," why? Because my mother will tell you what a good boy I have been all my life. So definitely I wouldn't have stolen. That's completely irrelevant, lah. But if, for example, the the relative can come and say that at the time of the so-called theft, he was at my house because we had a birthday party for my daughter and we cut a cake. So it's impossible for him to have been at your premises at that very time to steal. Then it becomes relevant. Okay, so that's relevance. But whether the panel wants to accept the witness's testimony, that is Budi Bicara panel, the discretion of the panel. Because the witness may come and say something which the panel is not willing to believe, or the witness may say something which the panel is going to believe. So then it's for the panel to decide, do I accept the testimony or not? Right? So there are two separate issues there.
Okay, next. Please advise whether it is advisable to include the punishment in the allegation statement if the accused employee concluded to be guilty. So meaning to say, I am saying, if found guilty, I may reserve the right to terminate you.
Yeah. So I think the way the question is phrased seems to suggest you want to identify, no, you will be dismissed. I would go with
Yeah.
what you mentioned, Zubra, which is
Mm.
if you are found guilty, you may be subject to disciplinary action, which may include dismissal. Right?
Okay.
You can say that, but do not say if you are found guilty, you will be dismissed, because that someone in court, I can see them turning around and see prejudge already, Yagari. Prejudge already.
Yeah.
They haven't even decided on guilty, but they're talking of punishment.
These are all the pitfalls that you can make.
Yeah.
Okay, next is this is a tricky part because we say good practice is to have three panel, right? But when a decision is being made by three panel, right? Say two of them say is guilty, one not guilty. So we will arrive to say majority saying is guilty, right? Would that
Yes,
be fair to say that?
that's right.
Okay. Unless one says not guilty, two says guilty, or whichever way, then you will take the majority, correct?
Yeah.
What happens? I cannot put three panel, okay, and I only got one panel member, or I only got two, okay. One says guilty, one says not guilty. So what do I do then?
Yeah. So it is for that reason that I would strongly encourage any employer, if you can't get three panel members, decide on one.
Okay.
Right?
So if there's no three, do one.
Yeah,
Don't try to be clever and do two and then get into a trap.
that's right.
But wouldn't having two would look as though that I am trying to be fair to the employee, instead of just having one person to just make the judgment of guilty or not.
Um, I guess you got to weigh the pros and cons, right? So to me, the impasse of not being able to move forward if one said guilty and one said not guilty is more of a pain than trying to show greater fairness by having two. So for in my mind, the way but if you, let's say someone says no, I think two is still better, then I would suggest you go in with a rule which says in the event there is a draw, Mr. A's decision will be conclusive. So the more senior of the two. So you've got your guiding principles up front.
Okay, the next question. Okay, is the chairperson selected from the panel members, or the chairperson has to be another person? I
It's
think this is.
yeah. You're right. It's from the panel, the three panels selected by the employer. One of them would be identified as the chairperson, Typically, it is the most senior or the person who's got most experience in conducting DIs.
Okay, I think we're almost out of time. We're actually, last question to you. If the panel found the employee not guilty, right, and have proposed to the management and we find the employee not guilty, but the employer feels strongly that he's guilty, can the employer or the management overrule the decision of the panel and proceed with their decision and terminate?
Yes, they can, but I would like to think that will happen for good reasons. And what those good reasons could be, generally, number one, a clear error by the panel members. Number two, what you say the reasoning process of the panel members not acceptable, right? So you need to have very strong reasons. I've been in situations like this where I've advised the client in cases where it's clear, go ahead, substitute. You need to, and I will fall back a little bit on Milan Otto. You see the fact that the DI said not guilty, but you substituted. You Any flaw in the DI is not fatal, right? So even if you say this is not right, you shouldn't have done this. Let's go to the court and let the court decide. Let's do the whole thing again in court, right? So it has happened, and in fact, I would basically I'd like to bring to your attention, to everyone's attention, that you would be surprised that most panel members are actually very much more inclined to finding not guilty than guilty, right? So you need to understand that that is the nature of human beings, in my opinion.
Yep. So thank you very
Sorry,
much, Daman.
yeah,
Yeah,
sorry, my
yeah.
phone rang just now.
Okay. Thank you, Daman. I think just to sum up the whole thing, maybe you can also help me since we are having a discussion. Okay. The first fact we would like to establish is, okay, DI is definitely not mandatory, okay, but it's a good process to have, okay. And if you can do a DI, right, with the best practices, the three panel, the full blown, structure that is being advised, it's good to do it. But if you are in a business, you're a smaller business and you are unable to do, you could seek external help to form your panel, right? And conduct some kind of an inquiry internally, right? So that's step two. But we also got to establish the fact that just having the DI doesn't mean that you can terminate the employee, right? Because the DI is actually one is another disciplinary step for you to establish whether the employee is guilty or not, right? Because you really need to show cause or establish the facts that he's guilty, that he has really done the wrongdoing. There are enough evidence and witnesses to support that. Correct?
Mm.
So that's the I would say that's the key role of the DI, right? So we have done one test internally. So before we actually come to the decision to terminate an employee or not, we have done our own investigation, we have done our own test, and we have gone through the process. Therefore, we then make whatever decision, right? And it's not like I do DI, I can terminate you, right? We need to. So I think this is to just to sum the whole thing. So we all understand the purpose of a DI, and we have also established some practices that the small, medium-sized businesses could adopt in a situation where a DI is required. But if you
Yep.
can clearly establish from the show cause that it's a clear cut, the employee has already admitted guilt to the offense or the act of misconduct, and it is severe enough that warrants dismissal, we can proceed with the dismissal. Would you agree with that?
Yep. I would.
Okay, thank you very much, Mr. Daman. This has been very interesting. It's good discussion. All right, and thank you everybody for participating. Well, till we see you again next one. Hopefully the lockdown will be over soon. Right, we need to get back to work. Thank you. Bye.
Thank you. See you all, everyone. Bye bye.